Thanks for joining us here at the First Alert Desk on Atlanta News First Plus. I am Maria Moreau, here to talk with you about developing news that just keeps getting more interesting here in Atlanta. Fulton County District Attorney Fani Willis, the one and only. You might have remember her from the Trump, Georgia indictments 2 years ago that have since followed her through into a hearing that grasped national attention into her romantic relationship with the top prosecutor on the case, Nathan Wade. Well, just earlier this morning, there was a Senate committee investigation in which they subpoenaed the Fulton County District Attorney, and she didn't show. Interesting. So let's get into some of the latest developments. We have Atlanta Attorney Josh Schiffer in the house with us. He'll be joining us to break down exactly what this means for the future of this Georgia election interference case and what it means for the Fulton County District Attorney herself. So a little bit of background. The State Senate Committee investigating Fulton County District Attorney Fani Willis, they met today earlier, wrapping up that session just a little over an hour ago. They are looking into whether there were any ethical violations into the Fulton County District Attorney's relationship with her top prosecutor, which she has, as of now, admitted to, but stays very forward with the fact that she doesn't believe that it had any impact on her investigation into the former president and the indictment that followed. Now, in the meantime, some major developments with the former president himself, the nation's 45th president, getting a bit of a win yesterday, in his words, as two charges against him in this Georgia case were dropped. Those two charges, we will get into a judge ruling that they were, quote, beyond the state jurisdiction and must be quashed. That we are going to break down here with you with our attorney, Josh Schiffer. Of course, the charges centered around conspiracy to commit forgery in the first degree and filing false documents. Now, Trump and his allies still face a number of charges in this Georgia election interference case. For the former president himself, 8 charges still remain on the table, and it's anyone's guess what comes out of that.
District Attorney Fani Willis back in the saddle after taking the stand.
You think I'm on trial? These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial.
As instructed by Judge Scott McAfee, DA Fani Willis can resume prosecution in the election interference case, but she now does so without Nathan Wade. In her letter accepting his resignation, DA Willis said, "Please accept my sincere gratitude on behalf of the citizens of Fulton County, Georgia, for your patriotism, courage, and dedication to justice. I wish you the best in your future endeavors." We went by Wade's private practice in Cobb County. He did not answer the door. While Judge Scott McAfee ruled he did not find a conflict of interest in the relationship between Wade and Willis, he said there was a significant appearance of impropriety. And Judge McAfee sternly added, "This finding is by no means an indication that the court condones this tremendous lapse in judgment or the unprofessional manner of the district attorney's testimony during the evidentiary hearing." Along with the former president, 18 others are also charged in this case. 4 have pleaded guilty, including Kenneth Chesbrough. His former attorney expects the defendants will appeal.
For all of the defendants in this case, I'm sure it's a sad day because it really just shows that while if they make mistakes, they might get prosecuted for it. If Fani Willis and her team make mistakes, if they lie under oath, if they show bad judgment, there's absolutely no consequences.
The ruling comes days after the judge dismissed 3 of 13 counts against Trump in the indictment. But with Willis and not Wade, the case carries on.
And an important distinction, 2 of the charges were against the former president, 1 other charge against his ally. Now, in this investigation, we still have a long ways to go. We still have yet to hear when trial will be. But just to give you some context on what this committee is focusing on, they are focusing on ethical violations and any that could have taken place. And all of this coming as the former president having these charges dropped against him in his eyes, and as his team has stated, a win for them in their push to get all of these charges dismissed. I want to take you out to our political reporter, Doug Reardon, with a look at these dropped charges.
McAfee, who's been overseeing this case from the beginning, dropped 3 charges from the indictment today. Some of the defendants faced all 3. Donald Trump faced 2 of them. They had to do with perjury, which is lying in court. McAfee said that because Trump is a federal office holder and the crimes deal with a federal election, as a state judge, he doesn't have the jurisdiction to prosecute them. Here's some of what McAfee said in his ruling today. Quote, because counts 14, 15, and 27 lie beyond the state's jurisdiction and must be quashed, the defendant's motion to dismiss the indictment under the Supremacy Clause are granted in part. Lawyers for defendants in this case, including Trump's, have been trying for months to get the entire case dismissed. So this is a big win for them, getting a few of these charges dismissed. Trump's team released a statement moments after the ruling came down. They said, quote, President Trump and his legal team in Georgia have prevailed once again, unquote. While Trump still faces a handful of very serious charges in Fulton County, this isn't the first big win for his legal team. He started this case last August with 13 charges against him. 3 were dropped in March, and then 2 more again today. We reached out to the district attorney's office. They could only tell us they were reviewing this decision. This case slowed to a halt after Fani Willis, the district attorney here in the county, admitted to having a relationship with the case's top prosecutor, Nathan Wade. That decision on whether to keep her or remove her from this case because of that is in the hands of a state appeals court. They will hear that in December, 1 month after the general election in November. Outside the Fulton County Courthouse, Doug Reardon, Atlanta News First.
So a lot of context that we just spent some time giving you, a lot of developments in the past 48 hours. I now want to break down and explain what all of this means and the impacts and consequences. And to help me do that is Atlanta attorney Josh Schiffer, a favorite here on Atlanta News First Plus. We so appreciate your expertise, and especially with this case, you've been following quite closely.
Absolutely. This is federalism 101. This is core function of government stuff, not just here in Georgia, but this reflects on our system nationally, because what we really are seeing is a fight between the executive and legislative branches. That's something that was talked about at the absolute formation of our country. We can crack open our old civics textbooks and realize that while this specific issue has never come up in Georgia, it's an issue that was thought about by our founders, and we're really going to have a unique result when the Georgia courts eventually get to weigh in on this balance of power issue.
So, Josh, I kind of already started previewing exactly what took place this morning with the State Senate committee meeting. Obviously, we heard about the subpoena involving Fulton County District Attorney Fani Willis. She didn't show. A number of other people didn't show for their expected testimony. And really now it's this argument from the Fulton County District Attorney's Office saying they don't believe this committee has the power to subpoena or the power to influence her in her efforts to prosecute the former president. And then the committee even today saying they absolutely do have subpoena powers, and having now an executive session behind closed doors to discuss what they are going to do next now that the district attorney didn't show.
And even though these are powerful people dressed in their finest, this is nothing more than literally a fight between 2 toddlers who both think they're right. We've got a legislature, and our legislature is elected, and they've got really specific powers. Those powers are delineated not just in our founding Georgia and federal constitutions, but there's a whole body of law that specifically empowers our legislature to do lots of stuff. And one of their major functions is oversight. And oversight colloquially means that they get to see how everybody in the state government and in the state is doing their job, so they've naturally got the power to subpoena people. But they're acting then as the legislative branch, and that's one of our 3 branches of government: judicial, legislative, and executive. Executive power, that's going to be our governor. That's going to be our highest county leaders. And in Georgia, each county has a couple of top constitutional officers out of the executive branch. This is the same branch of government that our governor, Mr. Kemp, is the head of. He's a standalone executive that has extraordinary power vested in his position through the voters of Georgia, just like district attorneys and sheriffs have that same level of power at a county level. And DA Fani Willis, as well as all the other DAs in the state of Georgia, are the highest prosecuting authorities in their specific counties. They've been chosen by their electors and been vested in basically unlimited power within what their office controls. Part of that power is not having to answer for what they do, because they are where the buck stops, and they are the finality when it comes to decision making about what to do and not do within their purview. And what we're looking at right now is a legislature that is empowered with oversight ability to see how the government is working, asking and being denied, and then subpoenaing a member of the executive branch, the highest representative of the executive branch in the county, that being Fani Willis, to come and appear before their investigatory committee. Now, for anybody but executive branch members, that's a really easy to sit. You go. They've got the power of subpoena. It's a remedy. If you don't comply with the subpoena, they can actually have you locked up. They're very, very powerful statewide laws there. But due to Fani Willis's standing as the highest judicial executive within the county, the highest prosecutor, she, under advisement of former Governor Roy Barnes, has elocuted that the legislative committee does not have the appropriate standing to request a subpoena from a member of the executive branch at the level that Fani Willis is at. That's not just Fani Willis, it's every DA in Georgia theoretically would want to agree with the analysis presented by former Governor Barnes on behalf of DA Willis. It's never been tested, though, before. The vast majority of these kind of issues, people willingly show up and they comply. It's a good political move to get out there and answer questions from the legislature as a member of the executive branch about how you are operating their office. But in these very contentious political times, that's not how Fani Willis views this at all. Fani Willis has viewed this investigatory committee, and she has good company. She has several other DAs that are supporting her on both sides of the spectrum. And they've basically said, listen, we run our offices because we are the executive tasked by the voters to run the office in our counties. We don't answer to the legislature. So the legislature does not have the power, the standing, to bring a subpoena requiring Fani Willis to show up, set aside all of her other business, her important duties as the chief prosecutor, and go pay attention to whatever the investigatory oversight committee is looking into. That raises also issues where Fani Willis holds privileged information, and she doesn't want to violate that privilege by sharing certain types of information with an investigatory committee, and it's not been determined by the courts what powers exist in this setting. So what we saw today was Governor Barnes, or former Governor Barnes, telling Madam D.A. Willis, don't show up. I'm not going to show up. D.A. Willis is up at a fundraiser, I believe, in D.C. or New York for the Congressional Black Caucus, speaking there probably on some law enforcement issues and raising her profile nationally, probably doing some electioneering up there, and didn't show up. That leaves the legislative branch to then ask for additional enforcement using the remedies that they're allowed under law. This is going up to the Court of Appeals immediately. How quickly that process is going to take, I don't think anybody can tell you. We're waiting for some of the filings that are going to come out from the investigatory committee. There are some very influential, mostly right-leaning Republican legislative members that are going to use whatever power they can to force Fani Willis to set aside her business and appear and answer these questions. Meanwhile, D.A. Willis is going to file her own response saying, no, doesn't matter the party politics. This is not a power the legislature has over people that have the executive power and discretion and duties that local DAs such as Fani Willis have.
So, Josh, in your words, this is almost a nothing burger, this committee investigating the Fulton County District Attorney's Office. Why go through these 6 now meetings, put this big show on and take the time with these representatives, these state senators, to investigate the office and in their words, put together a report advising whether there needs to be more to improve transparency for the district attorney and in general local prosecutors? I mean, why go through all of this if they ultimately can't touch the district attorney and her case?
While today's hearing was about Fani Willis, it's actually just one chapter in a much larger story, a big, long story arc for the whole state of Georgia. So let's step back for a minute, because this effort actually began long before the Trump prosecution that ostensibly is one of the reasons they're interested in speaking with Fani Willis. Recently, as in the last several years, there have been some issues in DA offices around the state, and there were grumblings down at the legislature about a couple of specific DAs that, in the minds of these legislatures, weren't fulfilling their duties appropriately. Very specifically, there's one out in Athens-Clarke County. You can go to Atlanta News First and read a bunch of different stories about the problems over there. That's what began this investigation. And then we add the Trump prosecution, the Cop City issues, which are multi-county. So this initial inquiry has expanded dramatically, wrapping up now Fani Willis. Very specifically, Fani Willis is a prime target for the right due to her role in prosecuting the former president, due to her role as a leading prosecutor in a progressive urban part of Georgia, as opposed to the more rural portions of the state. The legislature really wants to hear from Fani Willis and others about how DA offices are run. And that's because there's an argument over whether the state should have more control legislatively over the executive function of prosecutions locally. Traditionally, always been vested in the local district attorneys and the solicitors, who operated basically with impunity. They got a budget, they executed their duties, and everything was great. Now we've got this legislative committee that is interested in finding out how and why there are ostensibly failings in certain DA's offices around the state, and that goes to resource allocation. And as we all have talked about, how Fani Willis is spending her resources, is allocating her resources on these big gang trials, on the former president, on Cop City. That, in the minds of the legislature, is a valid inquiry. They're part of the purse strings operations of this state, and they want to know what's going on. They also want to score some political points. This is an inherently political investigation, just like kind of everything is these days. People are going to try to score political points for the people they love and support, and score points against those that they're opposing. And this would be a huge forum, a public spectacle of a district attorney getting grilled by a bunch of senators.
So you argue there's not a legitimacy here in what they're moving forward with, which is, digging into the Fulton County District Attorney, digging into her office, and discussing any ethical violations in her prosecution of the former president.
Well, and that's kind of the crux of the issue, is that they do have legitimacy because they're elected representatives and they're part of the legislature, and they control the purse strings, and the DA's office spends money. So they definitely have a legitimate political interest in the operations of state law enforcement. There is no doubt about that. There are lots of committees dealing with writing, managing all the laws that create our statewide criminal justice system. What the problem, the wall is, can they control these executives? Or what level should they be able to control or influence these executives? Can the power of their committee be used to harass, annoy, or obstruct the operations of these DA's offices? And with the goal being, at least from the DA's perspective, that DA's should be basically nonpartisan. Criminal law shouldn't be a partisan political issue. It's better for everyone if prosecutions are unified from a state position lacking specific political affiliations. And this is an attempt to investigate that, to look into that, to see how that will reflect on DA's offices statewide, because DA's don't all think alike. There are left-leaning, center, and right-leaning prosecutors scattered throughout the state, and we've got a public interest in keeping them independent and nonpartisan. So that's a big fear of the prosecuting agencies as well as civil liberty groups about making sure that our branches of government really are independent from each other and are not affected by harassment. And that's how DA Willis really views this subpoena. This is harassing. This is something that was crafted for political reasons to disrupt the operations of her office. She's not required to attend. She's not required to dedicate resources to respond to the inquiries. She certainly doesn't want to violate any of the privileges of her office, including privileged communications. So I certainly understand why DA Willis, probably with the support of most other prosecutors in the state, is telling the legislature, I'm not going to show up. You can go bring us to court. We'll see you in court. And I don't expect that to change. Former Governor Barnes, besides being one of our most prominent former state leaders, is a deeply experienced litigator, both civilly and criminally. His family has been running a law firm that I've known many people in, went to high school with them. They're great lawyers. They're not screwing around with this representation.
So they want to go to court if that is the next step for this investigative committee?
Absolutely. They want to go to court, and it's a novel issue. There are other states that have dealt with similar issues, so that's really the body of law that the appellate court's probably going to review. There will be multiple levels of briefing, including amicus briefs or friend of the court briefs, where different agencies, independent of the stakeholders, will come in and say, hey, Court of Appeals, Georgia Supreme Court, we know you're investigating and looking at the litigation on this issue of standing. Here's our position as an outside agency or interested party or even individual. Please listen to our perspective, because if you empower the legislative branch to force executive branch members to do anything, that's a risk no matter what part of the spectrum you are on, because at some point, whoever you like isn't going to be in power. And that can become a very abusive tool in the wrong hands.
Josh, I want to switch gears to the former president. Really bombshell developments with 3 charges in the Georgia indictment case that Fulton County District Attorney has brought forward. 2 charges against the nation's 45th president, dropped 1 other for his allies. Talk to me about these charges, because there was some confusion with this. So the judge ruling that charges 15 and 27, which relate to conspiracy to commit forgery in the first degree and filing false documents, would be thrown out because they were, quote, beyond the state jurisdiction and must be quashed. Break that down for us and really explain what the federal jurisdiction involved in all this means.
So the easy nutshell 10,000-foot view is that these charges may be valid, but it's not for a state to prosecute. They can be prosecuted federally if there's going to be a prosecution, because there are federal preemption issues involved. And it's Scott McAfee being an excellent jurist in reviewing all of the materials he can still work on as we're waiting for some of these initial appellate issues to be heard later this year, that being the recusal of Fani Willis's office. But the rest of the motions are still active in front of Judge McAfee. So he did rule. He took into account a very specific federal case, as well as the arguments presented by Steve Sadow and the president and his co-defendants counsel, and ruled that these charges specifically would have fallen into a federal-only purview, that they are outside of the power of the state to prosecute due to the nature of the allegations and the process in which the state brought these charges. That's not to say that the charges couldn't theoretically be brought federally. It's just that as a state agency, as a state prosecution in the Fulton County Superior Court, DA Fani Willis did not have the ability to bring these particular charges against the president and his co-defendants. So Judge Scott McAfee has quashed them. The rest of the indictment remains the same. It does not invalidate any of the other charges. It doesn't change anything dramatic. The core of the case is preserved for DA Willis as we await the rulings on her recusal due to the Nathan Wade relationship and everything, that all the water that passed under that bridge. But it's an interesting move, because we see that Judge McAfee is still working on the issues. There's still a lot of litigation happening in the background, and it's a good victory for the former president. It's exactly proving some of his arguments that Fani Willis's prosecution was in the wrong place and it was brought by the wrong people.
And let's talk about Mr. Trump's attorney here in Georgia, Steve Sadow, a well-respected lawyer in Atlanta, and now national attention around Mr. Seydow. Talk about these 2 charges. Can we see a pattern with the 8 charges that are still on the table? Can any of those get dismissed for I guess any of these reasons, or in his pursuit, as they say, getting more of these charges dropped until the case is in a much weaker position?
Well, it's absolutely something that happens during long-form litigation. As we are litigating here in Fulton County, other litigation is taking place. And in fact, Supreme Court of the United States rulings, as they come down, need to be incorporated in current cases, because once the Supreme Court comes out with an opinion, or another intermediate federal court or even state court, everybody below them has to say, okay, here's the new rules. Let's make sure we're still doing the right thing. Now, at the same time, the former president and all of his co-defendants, just like every citizen in the United States, has a right to a charging document that is perfect in form as well as substance. The way to fight that is to file a demurrer, and a demurrer is an argument to the court that these charges can't stand for one of a variety of reasons, such as being overbroad or not properly not pled with enough specificity. And in this case, it was going to be that the state prosecuting agencies did not have the standing and authority to bring the charges due to the federal preemption. And that was part of an overarching demurrer argument that actually attacked all of the charges. What is noted here is that Judge McAfee only moved on these 3, and that can be interpreted as a rejection of former President Trump and his co-defendants' arguments involving the other parts of the demurrer. And Fani Willis, in some ways, gets a win here. Sure, she lost 3 charges. The rest of them survived. That survival of those charges is a blow to former President Trump and the co-defendants, because it's Scott McAfee given the thumbs up, let's go, we can try these, to those charges in relation to the arguments for dismissal Mr. Seydow and his co-counsels had argued for.
We have a lot still ahead with not only this indictment, but really the recent developments with the State Senate Committee investigating Fulton County District Attorney and her office. Any final thoughts as we continue to follow this closely?
I just want people to listen openly and with open ears, listen to all parts of the argument. There's so much information, much of it accurate, much of it not. And that's the landscape that we as citizens have to accept. We can't change it. We need to use our critical thinking to realize who's saying what, for what reason, and determine what we're going to bring home and believe. And I hope that y'all are doing that and paying attention. This is historic. You talk about the Civil War. You talk about huge issues, turning points in our nation's history. This is one of them.
Josh Schiffer, attorney at law, regular here at Atlanta News First Plus. We so appreciate your expertise. I do want to make sure that if people ever need legal advice or want to connect with you for any reason, that they are able to do so. What's the best way to reach you?
I joke that I'm the last person you ever want to call. I've got the easiest sales job ever. If you're calling me, something's gone terribly wrong. You can always find me on Twitter at LawyerSchiff. You can Google me. Josh Schiffer. I think they're building me a new website one of these days. I've got this glorious practice where I just love representing people. So if you've got a problem, specifically a criminal problem or an injury problem, just look me up. You will find one of my gateways, and someone in my office will get your message to me. But thanks so much for having me. This is absolutely fascinating, enjoyable, and getting the front seat like you are doing right here. That makes my heart just smile. More people need to know about these actions every day.
Certainly. And for those of you watching, whether you are on Atlanta News First Plus or in our YouTube, but make sure you subscribe so that you don't miss these conversations. We are always streaming breaking news in Atlanta and the top stories that are happening and bringing analysts like Josh on to talk about it and more, so you can be part of the conversation. Hit that notification bell and we'll alert you when we're live. In the meantime, make sure you download the Atlanta News First app so you can stay on top of breaking news here in Atlanta. Have a great day.